this fantastic facility. I haven't had occasion to the humor that touched off at Rory yesterday was one of our local TV stations in Dallas wanted somebody to comment when the Supreme Court ruled in the abortion case. There was a lot of scuttlebutt that was going to come out Monday morning, so I got me lined up at 9:30. At which point, nothing happened. What came out was Tennessee versus Mississippi about the who owns the water supply for the city of Memphis. If you're from Memphis, that's a big deal. If you're not, a little less interesting. So I literally discussed nothing yesterday for a couple of minutes, and so we all acted like we were doing something and went on down the road, which is what touched off the tweet about coming to lecture about nothing. But all the joking around about that decided what Rory says is right. I've been 30 years since I took federal courts, and there have been two other times when I think that topic has been as relevant to the United States: the election cases, the Bush versus Gore 10, 15 years ago, and the Trump cases that we went through in the last election cycle. That was a big deal. That decides who the president was. This is the same thing. That what's in front of the Supreme Court right now is basically how the courts function as a branch of government. It's Marbury versus Madison type stuff. They may or may not jump in all the way. I suspect one of the reasons the opinion didn't come out yesterday is Chief Justice Roberts is trying to find some way through the wilderness that he can get a majority on and not have a bunch of opinions making a confusing situation even more so. But we're waiting for potentially very big news in how Article 3 of the Constitution functions along with the other two. And by way of background, there are two let's see here. Yes, this is the law that caused all the problems. And I'm going to talk about the law itself in just a second, but where we are procedurally with it, there are two cases that came out of Texas challenging this. There's a bunch of them, but they've been consolidated in two, which are both in front of the Supreme Court. One is the private case. I'll call it Whole Women's Health, or I might refer to it as the provider's case. It is brought by private actors against various government officials. And there are certain jurisdictional issues that come along with that. The other case, filed roughly a month later, is United States versus Texas. Much simpler in terms of parties. You got one plaintiff, you got one defendant. And so in that respect, it's simpler, it's cleaner, it avoids problems in the other, it creates problems of its own. The Supreme Court set them on an unbelievably fast schedule for oral argument, faster than Bush versus Gore, where the hard stop in the Constitution was right in front of everybody's face in like a couple of weeks, full briefing, and there it has sat for the last month or so. There is another abortion case that has been working its way through the normal process, set for argument in a couple of weeks, early December sometime. That came also up from the Fifth Circuit, and it involves a substantive issue about Roe versus Wade. It could be the Supreme Court's waiting to issue sort of a package deal, substance and procedure all in one. It could be that they want to resolve these cases promptly and get this situation straightened out, because the procedural issues are what's really more important here than whatever the substantive issue may be. We don't know. Only John Roberts knows. But that's where we find ourselves now. These two cases have been argued and are awaiting decision, and the substantive case has been fully briefed and will be argued in a week or two, and then we'll see what they do. So this is the law that caused all the trouble. It went into effect September 1, and it's referred to often by its legislative shorthand, SB8. The official name of it is the Texas Heartbeat Act. Like most statutes, it has a lot of lofty statements of purpose, technical definitions, but you get to this, the remedy section. It says that any person who is not associated with state government can sue any person who does these things: performs an abortion, induces abortion, knowingly engages in conduct that aids or abets. And that is simple. It's in one page. I've dropped out some stuff that's later in the statute, but it's really just one sentence. But it is devilishly complicated. It is the designer. That's not Rory, by the way. That's Professor Moriarty, evil scheming genius of Sherlock Holmes. But it is a brilliant piece of draftsmanship in terms of how it cleverly skates its way through just about every doctrine that has been developed over time to allow the federal courts to intervene and take review of statutes that are constitutionally problematic. It is a very, very clever piece of work. So there are four, this is what start to argue about things. Even the labels of some of these doctrines are subject to a little bit of debate. These are how I define them for purposes of this discussion. I wanted to spend a minute on what the topics were. People can argue about whether I've labeled these properly. Let's not do that today. But for purposes of talking, this is what I wanted to talk about. The first is something that I understand you haven't covered in this semester, Ex Parte Young, and the question of sovereign immunity and how it comes into play in these civil rights cases. So you'll get the 10 or 15 minute preview on Ex Parte Young. Standing, and its friend even more standing, because there's a lot of standing issues posed by this statute. The question related to immunity of state action, and I'm going to talk about what that means in the context of when the federal courts can interject themselves into a situation. And then a phrase, I don't know if this is in the briefing or not, it turned up somewhere. The United States with a straight face was talking about the equitable reservoirs, the reservoirs of equitable power that the federal courts have. They may have vast reservoirs, but let's just say in the Fifth Circuit, talking about equitable reservoir is a great way for your ship to sink in the reservoir. And I don't think it played real well in the Supreme Court either, which is why I don't think they talked about equitable reservoirs anymore there. But I kind of liked it. It sounds all learned, consistent with the goal of Thanksgiving dinner. You can say equitable reservoir, and people will be impressed. This is not a lot of doctrine. If you've had a chance to look through any of the briefing or you've seen any of the discussions about it, there are cases out there, but part of the genius of this statute is that there just isn't really a case about it. You've got some cases on this aspect of it, you've got some well-developed bodies of law about a couple of these things, but they aren't really relevant to the way this is drafted. So unlike, say, a personal jurisdiction question where there's tons of law, and the problem is just sorting out the inconsistencies in it and then finding what's most applicable to your situation. This is like, well, what book do we take off the shelf? It sort of is so outside the box. But there are a couple of cases I'll give it a little bit of discussion to by way of background, but not so much because they're controlling in sort of a traditional sense of the term. So Ex Parte Young and immunity is where I wanted to start. And to start with it, we have a little story. The kids that are here with me, by the way, my two assistants are here. Camden Cole, 8th grade, is there. Cecilia Cole, 16, is there. They were good sports and got up this morning. And as a reward for coming down here, we stopped at the Sonic in Italy. How about that? First class, traveling first class here. So I counted, it was 29 years ago, almost to the day, I would have been sitting in a Fed Courts class down the road in Austin at UT, and my professor was the eminent Charles Allen Wright. And he was larger than life, literally. He was about 6'4". He was a college football player, big guy, heavy. I mean, he ate a lot. Wore those three-piece suits all the time. Massive, massive presence, right? The Wright Miller Treatise, we've all heard of it. It's cited dozens of times a day by courts. Among other idiosyncrasies, he didn't stand when he lectured. He sat down because he was kind of old and fat, to be honest. But it made him even more intimidating to have this guy sit. And he didn't call on people. He'd been teaching so long that having women come to law school was a new development for him, and he felt it ungentlemanly to call upon women. So he just didn't call anybody. And he would just stop and ask questions, and people would answer his questions. He comes in, sits himself down. Class is silent, and he says, and he really did talk like Professor Kingsfield, really. I'm not making this up. It's not just my memory after 29 years. He really was like that. And he says, "What are the three most important constitutional law opinions from the Supreme Court?" Silence in the room. And at this point, I'd gotten in the habit of, on my way into class, I'd realized his lecture notes for the class were basically his treatise. He had a photographic memory, really did. Didn't bring notes to class, just kind of recited what was in there. If you stopped and looked in his treatise, you would know what he was going to say. So I noticed that one day, and I just got in the habit of stopping and looking. That's relevant, because the treatise had the answer to that question, but the case book didn't. And so I'm thinking somebody else looked in the treatise. So I'm sitting there quietly. People start raising their hands. It's a disaster. It's a bloodletting. Nobody, I mean, you would think it's Fed courts, somebody's going to get Marbury, right? He's going to act like that's a good one. And the next case in the book is Ex Parte Young, so maybe that's one of the three cases. People are Roe versus Wade and this and that and the other. Right? Just, no. No. Because Wright knows somebody out of the 100-odd people in this class has looked at the treatise, and he's going to wait all day. 10 minutes goes by. 15 minutes goes by. Probably every minute somebody knew it's getting silence. People are raising their hands. This deck is right. No! Finally, there I go. I said, an argument can be made that it's Marbury versus Madison, Young, and Martin versus Hunter's lessee. And the way he was angled, about half the class was behind him. All of my friends are over there, and they're going, good flip of the bird. He goes, indeed! And what would the argument be, Mr. Coles? You see, my friends are like, they know. You've looked at the treatise. You don't remember the, oh, yes, I did. I said, Marbury applies the federal constitution to the federal legislature. Martin versus Hunter's lessee as against state legislatures, and Ex Parte Young as against the state executive. I wasn't that snarky. My voice sounded more like, Ex Parte Young against the state executive. But I was right. And he said, and then they're like, you've never heard such carrying on in class. People were birds flying in the back of the room. And so anyway, that's why I remember that, is because I can never forget that moment. And I will say to this day, 29 years later, I have yet to read Martin versus Hunter's lessee. I have no idea why Wright thought it was such an important case. It's just one of those cases early in the con law book you kind of flip over maybe, and life goes on. So I'm not going to be talking about that. But I am going to talk about Ex Parte Young because Marbury is fundamental. Article 3 doesn't work without Marbury. That's the baseline. You don't have to cite it all the time. It gets cited, but it's just a make-weight thing. But it's definitional. Article 3 functions because of Marbury. But Ex Parte Young, you don't see it so much in my practice. It's more of a commercial practice. But in terms of civil rights, in terms of enforcing the Constitution, it is the workhorse of the federal courts. It is the way that the 14th Amendment is put into action in this country. This is the background principle. See 11. That's the 11th Amendment. And so the 11th Amendment says, well, it doesn't say, but the Supreme Court has told us that it says you cannot sue a state in federal court. Period. Hard stop. It's the 11th Amendment, right? The first 10 are the Bill of Rights. This is the first thing that we got around to amending the Constitution about after the Bill of Rights. The reasons for this have to do with a bunch of money that was owed as a result of the Revolutionary War. They're lost to the sands of history, but the principle is still there, and it's been rock solid for as long as we've had the 11th Amendment, which goes back to about 1800 or so. You cannot sue a state in federal court. This brings us to the late 19th century, beginning of the 20th century, and the railroads. There's two railroad cases that I'm going to talk about today that define the structure that leads us into our abortion statute now. One is Ex Parte Young, the other being Debs, that I'll talk about in a little bit. But what happened was, the golden spike is driven in about 1870. The national railroad network begins to develop. The nation's economy grows by leaps and bounds overnight. And the state of Minnesota basically decided to shake down the entire country. The regulators at the time had set the freight car at X. I forget what it was. Minnesota said, in Minnesota, it's half of X. It's going to be significantly lower. If you don't like it, we're going to charge you criminally and fine you hundreds and thousands of dollars, which at the time was a great deal of money. And if you really don't like it, you can move your train. Oh, you can't, because you spent millions of dollars laying it down. So let's see the money. And the railroad said, well, this is crazy. We've put down rail all over the country. If you guys get away with this, we can't function. There's no way. We have to have this national price in order for the railroads to work. Minnesota said, that sucks to be you. Write us a check. And so the railroads sued Minnesota and everybody they could find associated with the law in federal court in Minnesota, because if they sued in state court, the state judges were probably going to defer to the Minnesota Treasury. The gentleman with the big mustache is Arthur Young, who was the Attorney General of Minnesota at the time, and he was in charge of enforcing the statute. He's ultimately, the federal court rules for the railroads, finds that interstate commerce carries the day. Young is held in contempt, and it finds its way to the Supreme Court. Young confidently says to the Supreme Court, I'm a state. I admit the state is Minnesota and not Mr. Young, but I'm the Attorney General. The only reason I'm being sued is because I'm a state. You can't do this. Since the 1800s, you've held that a state cannot be sued in federal court. I am essentially the state. You can't sue me. And so the court has a problem on its hands because that's literally correct. You can't sue a state in federal court. On the other hand, if you don't allow this state to be sued in federal court, the national rail system is going to fall apart, and they're going to have another panic on their hands, and a bad one. So the Supreme Court cogitates for a while and comes back and says, we have an answer. You, in fact, are not a state. You're an individual named Mr. Young, and you're being sued in your official capacity. We just came up with that. That sounds pretty slick, doesn't it? Official, it's like equitable reservoir, official capacity. But with that way, we get around the amendment doesn't say a thing about suing people named Young or Smith or Ryan or anything else. It says you can sue all the people you want to in federal court, subject, of course, to the other rules. So you're an individual. It happens to be you're an individual wearing the hat of the Attorney General of Minnesota, and this is the key language from it, your office and your power by virtue of your office connects you to the duty to enforce the law. Unquestionably true. He was the guy that brought the prosecutions against the railroad that caused all the problems. You're the guy. And so an injunction against you personally in your official capacity will solve the problem. We don't have to sue the state. We just have to have an order against you. Stop bothering the railroads. And so they carved that little area there and went on down the road. That became invaluable as the civil rights revolutions of the 20th century went forward, because otherwise you think about the abortions. Roe versus Wade. Why is that Henry Wade and not Roe versus Texas? Because you can't sue Texas in federal court. You can sue Henry Wade all day long. And he's sued in his official capacity as he was in charge of enforcing the Texas criminal abortion statute at the time. Interesting footnote, this comes in handy later. The court is talking about one of the other arguments Young said is well, there's going to be, once we impose criminal sanctions on these railroads, they can appeal. They can challenge. They got some constitutional problem. The courts of Minnesota are open to them. They can argue all day long. It'll go to the Minnesota Supreme Court, and if the U.S. Supreme Court wants to hear it, they can hear it. There's plenty of time down the road to hear about that. The Supreme Court says no. In the meantime, they're going to be out of business, and their agents are all going to be in jail, and this risk is something the company ought not be required to take. You might be hearing echoes of some of the discussion that we've had about the abortion statute, because the genius, one of the genius moves of our SB8 is that language about any person. Anybody can bring a lawsuit against anyone that has anything to do with an abortion other than getting one. But a provider, someone that drives their friend, you're good to go. And there's no res judicata stop in there. You can just keep suing over and over again about the same thing. That's why, since SB8 went into effect, the number of abortions in Texas has plunged, because they're afraid of crippling liability. And that's the issue in front of the Supreme Court right now. It's the big flood of lawsuits never happened. There have been a couple of lawsuits filed that are just curiosities. But the fear of the flood has had a very real effect on the exercise of whatever right is guaranteed by the Constitution with respect to abortion. So this language about risk is quite relevant in this context. We forget about that because most people look at Ex Parte Young and think about the kind of Marbury sleight of hand move there of coming up with the notion of an official capacity. But the idea of litigation now is difference-making, existential, compared to litigation later is an aspect of Young that we forget about. But it's relevant, it's part of the opinion. Which brings us zoom forward in time, a whole bunch of stuff, to Whole Woman's Health versus Jackson, an Ex Parte Young case. This is the private case. Whole Woman's Health, an abortion provider in the Austin area, litigious one too. It's frequently the named plaintiff in some of these cases going back several years. I forget who Jackson is. But they sued a number of state actors. They sued some clerks, they sued a defendant class of judges, they sued Ken Paxton because why not, and a bunch of other people. And this, the Fifth Circuit was real interested in this case. They actually took the case before the district court ruled. The district court had a temporary injunction hearing set on Monday or Tuesday, and Monday, this Fifth Circuit Sunday, the day before the event was going to be held, the Fifth Circuit said, we're feeling supervisory today. We're going to have we're issuing a supervisory writ, and we're going to writ all this. And so they writted everything. That went to the Supreme Court in early September, and then an opinion came out a little bit later once they had a little more time. And this is directly language out of Ex Parte Young. They say, all right, let's go back, let's look at that. Mr. Young is the case study we ought to look at. What was he? He was the guy in charge of enforcing the statute. If he couldn't enforce the statute, it wasn't going to be enforced. If the Office of the Attorney General couldn't bring a prosecution, there wasn't going to be a prosecution, there wasn't going to be a problem. None of these people has anything to do with enforcement of the statute. They're just private litigants or they're judges and court staff. Those people aren't making the decision to bring lawsuits. And in fact, not only, I think I spelled suable wrong, but not only are they not people like Young, but the statute expressly says if you have anything to do with the state of Texas, you can't sue. So whether or not you're the Attorney General, if you're like work for the state postal service or something, you can't sue either. You have to be completely removed from the state. So they say not only as a practical matter, these people aren't doing anything like Mr. Young. Anyone doing anything like Mr. Young physically can't under the way this has been worded. So that simple sentence about any person who is not the state brilliantly gets around the definition of official capacity in Ex Parte Young. And the Fifth Circuit continues on the subject of suing state court judges, state court clerks, and other such actors. It points out, this quotation is from a longer discussion, there's more case law behind it, but remember, Young was a decision maker. Young would say, I'm going to prosecute the such and such railroad for violating our shakedown law here in Minnesota. But all clerks do is take things for filing. I can go to the clerk with my $10 filing fee in my lawsuit, or whatever the filing fee is, and says, I would like to file an unconstitutional lawsuit. I would like to get a remedy that is abusive and violates prohibitions against punitive damages. Will you take that? What you're filing? Care. Their job is to take things and file them. And if they look like what is supposed to be accepted under the rules, they take them. And judges, they don't do any of that either. They just sit there. They receive cases or controversies the same way the federal courts do. People just show up and present cases. They make decisions about the cases. They apply the law, but they don't make a decision to bring the case in the first place. And Ex Parte Young itself says that a judge cannot be sued for that reason. This is the language itself explicitly is in determining its discussion of who can be sued. It's dicta. I don't think they sued judges in that case, but they're saying, let's be clear about this. Young can't sue. The courts sue because they make a different kind of decision. They're reviewing the case. They're not making a decision to institute the prosecution in the first place. It goes on to cite some other case law. So that's the state of the law in the Fifth Circuit in October as they see Ex Parte Young. There's Mr. Young. No state act, no enforcement connection for a couple of different reasons. As to the judges, it's even further out there because of the nature of what they do. So this is the issue, the question presented at the Supreme Court as it has formally stated it in the private case. It's under review right now. And the language is a little slanted. You can tell the petitioners drafted it. But can a state insulate from federal court review, blah, 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 by delegating to the general public? That's the question. The arguments, I commend them to you if you're interested in that sort of thing. They're technical. They get into a lot of ins and outs about Young. A couple of interesting features of them. One is how you pronounce Ex Parte Young. I think it's Ex Parte Young. How many of you think it's ex parte? Ex parte? A surprising number of Supreme Court justices say ex parte. I think it was Breyer. I mean, these guys, it's got that patrician Boston accent of his, going to Ex Parte Young. What are you talking about? And it was more than one of them. So there's apparently some part of the country that thinks it's Ex Parte Young. So it's kind of interesting to hear that. The arguments are very good. Elizabeth Proligar, the new Solicitor General, is outstanding. She's super efficient, really interesting to listen to. The presentation on the respondent side, the state Solicitor General argued for Texas. He's very good. The drafter of the statute also spoke, a guy named Jonathan Mitchell, who had been a Solicitor General some years ago. He doesn't really represent anybody. He represents some Amici in the case, but he wrote it, so why not hear from him? You talk about a frosty reception. I mean, this is a guy who's telling the Supreme Court, I outsmarted all 9 of you. That's right. You guys think you're smart, I'm smarter, because I came up with a statute that puts you out of business. And I don't think he got a question in the 5 minutes he argued. So you can't tell what the court's going to do from that, but icy was the room when he argued. And his position is unadorned, what it says in the first line. A state can, and this state did. We don't have to allow federal judicial review. It's interesting you have these rules like Ex Parte Young. We didn't write it that way, and you're just going to have to deal with that, federal courts. Generally, daring a federal judge like that is unwise. Don't do that in your practice. But that's the question, is whether this machinery gets around, has successfully shut down private litigants or not. And there's the tension. I found the tug-of-war clip art thing and thought it was kind of cool. You have a tension between who exactly is it in the government that you're enjoining. Because the second you expand it past Mr. Young, are you sticking your nose in too far? Are you starting to run the state courts for them? Are you starting to run administrative agency? Are you substituting the judgment of the federal courts for political judgments by the state? And on the other hand, you have the practical problem that the National Railroad is on the brink of with it, the national. In Texas, that the rights guaranteed by Roe and Casey are in trouble. They're there, they're on the books, but it's very, very hard for lots of people to actually do anything with those rights. And so that's the balance that is present in any Ex Parte Young case. There were tons of these during the election in the last cycle, different issues, but similar kind of balance, and that's the issue in front of the Supreme Court now. So I'll go to number 2, standing by the longest of segments. I wanted, since I know you hadn't talked about it before, I wanted to just lay out what happened in Ex Parte Young. I'm open to questions about it. I'm happy to carry on, but I thought I'd stop, take a breath. While I was taking a breath, politely ask if anybody had a question, and then resume with standing in just a second as I sip my coffee. You don't have to ask. You can ask. Go ahead. Ask. I was going to say you don't have to ask, but then he asked, so that's cool.
So in terms of the enforcement and the role of like clerks and judges, I saw that Holden's Health only cited Shelley v. Kramer once. Why isn't Shelley v. Kramer kind of more authority?
That's a very relevant case. I'm going to discuss it when I get to state action, but that's the case the other direction. And it applies to Young as much as to the state action question. Let me cover it there. Okay. So Shelley versus Kramer is a civil rights case from right after World War II, but it involves clerks. And it's, as the name suggests, it's an Ex Parte Young, Shelley versus Kramer. Kramer's some clerk somewhere. And that's kind of the high watermark of state action. They're held there that a clerk that accepts a racially restrictive covenant for filing is engaging in state action and is thus the kind of person that is subject to an Ex Parte Young lawsuit. The court hit that high watermark and it's been back down ever since then. That's a substantial intrusion into state affairs, but nevertheless the law's been on the books since the late 40s. So that's the case. The court has to, among the many things the Supreme Court has to do in resolving this is that pesky Shelley case. Do you apply it literally the way it's written, in which case it's a strong case for the challengers? Do you kind of follow the trend of backing away from it, in which case it just sort of fades away? But that's the moneymaker on that particular issue is Shelley for sure. Let's do a little standing. I'm standing. You're sitting. Law is such a funny thing. All right, so this is the basic rule. We take it from, actually that's the wrong site on that case, but forgetting the site, that's the general boilerplate black letter for standing. Who can bring a lawsuit in the federal court? You have to have a personal stake. Your fish has to be different from all the other fishes, something about, you cannot just be a concerned citizen and bring a lawsuit in the federal courts, because otherwise we would never get anything done. There'd be millions of concerned citizens and we'd never be able to the courts just would freeze up and not be able to function. So that's the black letter definition. Let's take a look then at, well, before jumping into that, let's pause for a second. Remember there's the private case and there's the public case. The private case has a big problem with Ex Parte Young and the 11th Amendment issue. And so resolving that is sort of the threshold problem out of the gate for the private case. The United States case resolves that problem largely because the United States is not bound by the 11th Amendment. The reason the 11th Amendment is the way it is a notion that states have sovereign immunity. The United States has got more sovereignty than the states do, and so the 11th Amendment restriction doesn't apply to it. So Ex Parte Young is not an issue for the United States. Standing, however, is a big issue in that litigation for the United States. It's a lot easier at Whole Women's Health for the providers. The point, though, is not free from doubt. There is discussion at standing in the Fifth Circuit's opinion in the private case. I didn't get into the details of that here. Just to note that the private actors have a better standing argument in that case than the United States does in the United States lawsuit. But the point is debatable, even as to the plaintiffs in that case. However, in the United States action, which remember is just United States versus Texas, Ex Parte Young's back on the shelf, we're not talking about it. This is the issue statement in that case. Can the United States sue a whole bunch of people? Or may the United States sue them? Well, I'm just kind of, there's not a lot of good guidance in the cases on this. There's a million cases that have that standing framework. There's a ton of them from the election cycle that basically said interested parties that dress themselves up in political clothing are still not interested parties. But the United States essentially has made two arguments about standing. These are excerpts from Texas's brief, so they're biased. I'm not suggesting this is what the law is. I'm just trying to illustrate what the arguments are. They made two arguments about standing. One is there are a number of federal programs that are affected by SB8. There are programs that in some way or another encourage, enhance, develop, fund the availability of abortions. And these are some examples of them. The people that are in federal custody, ORR is a type of immigration custody. The Job Corps, people live in Job Corps facilities and work. It's kind of a quasi jail thing, learning about getting jobs type of thing. And there are problems with that. For one thing, it's a real question whether the statute applies to federal facilities and programs. Open question about that. But just going along with that for a second, the state response to that is, really? Really? Who are all these people that are wanting to take advantage of their constitutional right that are in DOP custody? There aren't any. So theoretically, sure, the Bureau of Prisons or Immigration or the Job Corps or whoever has some custodial responsibility, but you're not really exercising it. There's not a long line of people here. And if you weren't the United States, no one would give this the time of day. There's a related argument that's probably better for the U.S. About funding through Medicare type programs and federal support for certain medical procedures, which includes abortion. That's not discussed in this particular section of the brief. That may be how they ultimately get standing if they go there. But suffice to say that just because you're the U.S. and you're, well, ignoring the argument I'm about to put up, just like any other litigant, the U.S. has to show it's got an interest that's unique. And it tried mightily to point to a number of specific programs. Very serious question whether it did that. Because while the programs in theory are affected by SB8 as a practical matter, it's pretty shaky and it borders on speculation about the future, which is a no-go in standing law. The other argument, I see what I think of it from the graphic, but is this notion of parens patriae, which is a fancy Latin phrase for something. Some states have a belief that their state has what's called a parens patriae, interest in the general welfare of the people. And so the state is able to bring lawsuits to sort of enforce consumer laws or protect consumers, even if there isn't a specific consumer statute, that kind of thing. Texas doesn't have that. We don't have a doctrine in this state. Our state can only act legislative authorization for them to do something. Does the United States government have a parens patriae? The loose Latin translation is like a parentage type of thing. It's sort of a big brother general interest in things going okay. Probably not. Surprisingly, no case law about that. A pretty good argument is no, you don't. There is no federal police power under the Constitution. The police power, life, is something reserved to states under the 10th Amendment. It's probably wasn't the intent of the framers of the Constitution to give the U.S. government a general interest in the well-being of everybody, but they didn't say you don't have it either, and there's some cases that are kind of here and there. So that's the U.S.'s fallback position in that case is, okay, so maybe programs are a little shaky, maybe the whole funding thing is a little much, but I mean, we are the United States, this is an important interest, and we would like to do something about it. That's an interesting argument. Of course, trying to put a boundary around it is very difficult because once you say the U.S. just has a sort of general interest in how the laws are being enacted or how people are being treated, where do you draw that line? That's very hard, particularly without a lot of case law giving you instruction on that. So in some ways, the easiest argument for the U.S., look, we're the friggin' United States. It's our Constitution. Get out of the way. But well, I don't know about that, particularly with the judiciary and the Fifth Circuit and the U.S. Supreme Court that's dominated by conservative thinking. Even more standing. So these are the standing problems in the litigation. Who can challenge the statute? The private actors, There's some arguments there. The United States solves Ex Parte Young, but the United States is an actor like anybody else. They have to have an interest, and there's some serious questions there. Then we get to the statute. Let's forget all about the federal stuff for a second. Let's just assume that all the federal litigation goes away and we have one of these. And someone shows up, pays the filing fee to the unenjoined clerk, and they proceed. And someone says, "Who are you?" "My name is Joe." "Where do you live, Joe?" "I live in Waco." "What are you suing about?" "I'm suing about somebody that drove Sarah to the abortion clinic in San Antonio." "Okay. Do you know Sarah?" "No." "Do you know the person that drove them to the abortion clinic?" "No." "How'd you find out?" "I saw it on the internet. I looked at the Who Can You Sue Today website, and they were listed on there by a group that seems to specialize in those things." "How were you hurt by that, Joe? Did you see them go there?" "No." "Were you there when it was being performed?" "No." "Did you pay for it?" "No." Did the car hit you on the way to the clinic?" "No." "Why are you here, Joe? What interest do you have that is different from the general public?" "Well, I really don't have one." But the statute says any person and isn't limited by that principle. And I'm a person and I don't work for the state. And that person, I have evidence, knowingly engaged in things that violates the statute. So I'd like to bring a lawsuit and collect my $10,000 bounty, and I can then go on and collect later on. That's a head scratcher. And so we have the question whether a legislature can just sort of abrogate the standard rule of standing and say, the courts are open to you, is something that I think the courts of Texas are going to be skeptical about, both as a matter of constitutional law, as a matter of state procedural law, that's great, legislature, that you thought that, but we're not going to let you do that, because the same reason that's a general requirement in court is the same reason why it has to be sort of a baseline requirement about how the courts operate. You can't function if the legislature can just let anyone show up and bring a lawsuit. But the argument the other way is the legislature can do as it pleases in defining causes of action, and it chose to define this one broadly. So there's the standing issues on the pending litigation are one thing. When and if and when this is returned to the state courts and certain constitutional issues get taken up there, standing and the contours of it are going to be a huge deal in the state courts. Why are you here? And why are you talking about stuff that you weren't involved in? So that's standing. I don't think I can answer questions about standing, but I think it's sort of largely self-explanatory, and I'm still standing after that. So let me go through state action, and we can kind of catch up and see where we're at. And this came up in discussion earlier. Closely related to Ex Parte Young. Young is about, though, assuming you have a state that has acted, Texas, Minnesota in that case, how can you bring them into court as a private plaintiff? Here, there's a question of, did the state act at all? And this is not a theoretical question. The 14th Amendment is where this comes from, and it is then picked up by other laws. But it's limited to a state, and for a very good reason. Right? The First Amendment, the Bill of Rights, which is largely incorporated by the 14th Amendment, is a check on government. The first words of the First Amendment are, Congress shall not. And that's the only way it can be. You can't have a Bill of Rights that checks private citizens, because that's not a Bill of Rights anymore. The Bill of Rights restrains the government that's created by the Constitution. The 14th Amendment continues that, and it's limited to things that states do. So you have to have state action for this amendment to be implicated and to have another civil rights claim come to the courts. And it's an important limitation on what courts and the federal government, for that matter, can do as between public and private affairs. Then we have the statute. Devilishly clever again, one little sentence, but remember the sentence before? You have to have state action. The law says the only person in the world, aside of someone who's incompetent or something and doesn't qualify as a person, that cannot act under this statute is the state. Got to be state action, not the state. Clean, simple, clear and persuasive to the Fifth Circuit, albeit in Ex Parte Young, not talking about state action, but you got to be the state, it's not the state. And so is that argument correct? We'll talk about the pros and the cons of it here, but is it simple and elegant? Heck yeah. You got to have state action? No state action. I said it in one sentence. Arguments that you can say in one sentence are usually fairly strong. So ingenious bit of drafting on a fundamental threshold question. We can't even open our mouths about the Constitution unless the state did something. And if there's no state action, we're done. It doesn't matter about Ex Parte Young, it doesn't matter about standing, it doesn't matter about anything else. The state didn't act, the Constitution isn't implicated. So I got my clever graphic. X means not state action. In a minute, state action. Pretty slick, huh? Yeah, X's. Clip art is great. So this is a case, what did it come out of? This is a Batson case from way back when. But in the course of resolving the Batson issue, it made the comment, consistent with what you saw earlier about Ex Parte Young, that the decision to file a lawsuit, the decision to pursue discovery in a lawsuit, the decision where to file the lawsuit, that sort of thing, that's not state action. That's private stuff. Private actors make those decisions. The state is there in the background. It's there to be taken advantage of, but it's like the electric company or something. It's just a tool. It's something that private actors make decisions about. And historically, in this section, the opinion, it cites cases that support that principle, that that's not state action. It ultimately goes on, by the way, to find that a race-based peremptory strike is in fact state action. So it shows this can get kind of slippery. But the concept that a private litigant and their ability to make their own decisions is sort of similar to a state judge's independent ability to make decisions for purposes of Ex Parte Young, it's sort of a reinforcing idea. And related to that is this argument is treated very shortly in the briefing in the Supreme Court, but it's an important principle. An argument made against the statute is, well, no, wait a minute. You've deputized the entire state. We've all heard vigilante and all that in the media coverage of this. Yeah, it says any person. That's cute that you said no state in there, but nobody would have this claim if you hadn't passed this statute. There's no common law tort for I heard somebody talked about an abortion down the street. That's not a cognizable claim. This exists because Texas made a deliberate choice for it to exist. And you admittedly created a very big class of little deputy sheriffs on this, but you did it. This is something you did, and you put this ball in motion. You have made them, in some sense, agents of the state. The answer to that is, and this is in the state's briefing in the U.S. case, is, well, not really. Agency means control. This is section 1.01 of the restatement. It doesn't just mean I let you go do it, or I gave you general instruction. I have to be guiding you in how you do it. I can guide anybody, says Texas. I passed a law. I set out certain remedies that you're able to take advantage of. I put in some procedures about where you can sue. Who wants to? That's your business, not mine. And in fact, for Texas. Now, I say nobody used it. People have chosen not to bring those lawsuits. We didn't have anything to do with that. We had no idea who would show up, and frankly, we're surprised that nobody took this law that we passed. So, there's that principle. Going the other direction, you have, this is the district judge opinion. So remember, there's the private case, there was a judge case, the circuit jumped in and went up to the Supreme Court. The U.S. case did go to preliminary. Judge Pittman in Austin granted the preliminary injunction, and then it went through the Fifth Circuit up to the Supreme Court. And the Fifth Circuit writing a very, very short opinion because it knew the case was just passing through. They didn't take the time to really write anything. They wrote a short, like, two-page thing that's not very good, frankly. It talks about Ex Parte Young. Wrong plaintiff, guys. They clearly just kind of dashed something out and hoped that it would go away, which it did. But the argument that Judge Pittman makes on this point is the point I was just making about putting the ball in motion. The delegation is state action. There was nobody, no action was possible until you went and passed this goofy law and let these people have this cause of action. You flipped the first domino, and yeah, okay, it was up to people to bring the lawsuits, but you didn't pass the statute thinking people were just going to ignore it. You passed it so people would have the ability to bring lawsuits, and that is a sufficient action by the state to trigger constitutional protections. And then Shelley versus Kramer, that we were just talking about, the restrictive covenant case, if I go to the clerk and I try to file a restrictive covenant, they may file it, but it's not enforceable. If anything is done in the clerk's office to try to actually do something with that, that is state action. And as we actually have one at our house, it was split off from the original lot back in the 30s. It is a devil to get rid of those things. It would cost $100,000 easily to go around the neighborhood and get rid of it. Suffice to say, it's not enforceable. Shelley versus Kramer. Why am I worried about it? I'm not. But this case is practically important because there's just no other way to get at this problem than going at the clerks. You can't expect people to go around rooting around all these old title documents. So you've got the clerk there. you have kind of a combination. Remember, the issue presented here, wherever it was can the United States sue all these people? Somewhere in there is somebody you can enjoin, is their thinking. And if it's the state itself who's the named entity, well, the state itself is who enacted the law. And if it's a state official of the clerk taking it, then that might be something. And really, the way it's played out since the enactment of the statute puts a little more meat on the bone of Shelley versus Kramer than you might have thought at first, because the problem has turned out not to be a sea of lawsuits. There haven't been any. What happened was the providers all went, we're going to go broke if we have to litigate that, so we're just out of business. We're shutting down. So the problem really is the filing. The simple ability of the clerk to accept these lawsuits and put the litigation process in motion has turned out to really be where the meat is on the bone of this statute, and no one's litigated the thing yet, so we don't really know anything more about it. So there may be something to this that you might not have thought of otherwise. The case, everyone agrees Shelley is correctly decided, basically because it's such a pain in the rear to deal with real property records otherwise, but it's cited an awful lot and distinguished an awful lot. To say that a clerk that really just takes things for a filing fee is a state actor is pretty broad. And the Supreme Court has not been comfortable building on Shelley into other relationships involving sort of ministerial type acts by state governments. So yeah, filing here has got some unique things going for it. It's caused some unique problems, but the rule in Shelley's case, a little property action there. Is I heard some groaning in the back there, is something that the conservative judges that sort of dominate the Fifth Circuit and the Supreme Court, I think, are not very comfortable with. So that's the tension there. You have, on the one hand, is the state abusing its power? On the other hand, you have the question of, who is actually making the decisions? Yeah, the state's involved, but who's driving the train? Is it a private litigant, or is it some state decision maker? So I'm going to pause there before talking about equitable reservoirs, because I just want to say I had lots of energy when I get into the reservoirs. Questions about Ex Parte Young is fine too, standing or any of the state action stuff that we just talked about. Sir.
So how then can Texas be a named party to the suit? Because my understanding was Young, did they consent?
Well, that's the whole. Well, that actually is the Texas's side of the case in the Supreme Court is why are we here? But in the private case, they can't be. The 11th Amendment bars that. But in the U.S. case, it's just an exception. The U.S. can sue a state in federal court. It just can. The 11th Amendment rule just has a carve-out for that because of the nature of sovereign immunity. The state is in some sense, not really, a subset of the United States. The 14th Amendment came after the 11th Amendment. There's just a pass. Now, the practical question that was raised in that litigation by the Texas Solicitor General is, why are we here? I get it. The other case is a mess. You've got the defense class action of all these judges in Texas and all these clerks, and I get that it's simpler to just sue us. What did we do? We're a state. We didn't do any of this. And you're saying that we did. Who did it? We're not just some entity. If it's the legislature that did it, what do you want to do? Go undo it? If it's the clerks, how do we tell the clerks to go do it? If it's all suing, how are we responsible for them? Are we supposed to go and give notice to 10 million people that might give lawsuits? So I know you want to make us into a one-stop shop, but you can't do that. Injunctions can't be against one to make them regulate the affairs of millions of other people. That's just not fair as a matter of remedies law. Here, different U.S. case, but a very relevant question posed by Texas.
There was a footnote, I didn't read the cases cited in there, where at least the SG's brief claimed that it has not been unheard of to issue a general injunction against, say, the chief executive of the state and say, you've cluttered this up so much that we don't know who is to enforce it, but you're in charge of the state, so you figure it out.
Yeah,
I didn't read the cases, but they were in that.
Like many of those standing cases, it's one of those things where there's a half dozen cases that have involved different situations over the years. Good luck. There's not really a binding case on point. Texas's argument is what I just said. That's far from clear. That's necessarily carries the day, but it has some appeal. I mean, I'm more of a commercial practice, and you have the cases that come up all the time of the guy that leaves and takes the secret stuff. Well, you can get an injunction against him, but what about the other guy, and what about the new employer? And yeah, I have a right to get my secret stuff back, but I can't just go enjoining everybody in town either if they're genuinely a stranger to the case and so on and so forth. So who is bound by an injunction? It's a serious matter. When you're talking about being able to throw somebody in jail for violating a court order, well, you know, you need to be sure that they had notice and opportunity to be heard. So the point is subject to a lot of debate without a lot of clear guidance. Is there another, ma'am, I'm sorry.
So from a supremacy clause standpoint, isn't it problematic that Texas has attempted to abrogate Article 3 standing in diversity cases?
Absolutely. Yeah, no, it's a serious question. Is it a question that's ripe for decision now? Well, that's the $64,000 question. The first thing, if and when one of these cases comes up in state court, the first point they're going to make, assuming Roe is still the law of the land, will be this violates the guarantees of Roe and Casey. And the second point is going to be, who are you? Why are you talking? And make the standing arguments that we were just talking about. Here, in this litigation is more about the act of just having the lawsuit rather than the point that the statute as written purports to allow a whole bunch of people to sue, which would then lead to a bunch of litigation about standing, which is the reason why it's a problem, is you have to spend all this money in court. But it's more about the fact of having to litigate the issue than who would actually win at the end of the day. All right, good stuff. We're standing. Equitable reservoir. You're thinking you can see the turkey. You're going to drop equitable reservoir. What time do we conclude, Rory?
35.
Oh, at tons of time. So, Equitable Reservoir. This shouting fellow is In Re Debs, a real firebrand activist in his day in the late 19th century, early 20th century. Spent a lot of it in jail for various reasons. Some of his activity today would be regarded as socialist. Some would be regarded as mainstream policy. But he was at a time when we were much more free market, Lochner ruled today, all that sort of thing. And what he's shouting about there is before he became a sort of a professional presidential candidate in the early 20th century, and spent a lot of time in jail for that too. But before he became a professional presidential candidate, he was a labor union leader, and a pretty effective one at a time when unions were really without much power in the country. And remember the rail expansion? Everybody's worried about railroads. Minnesota's over there trying to shake down the country. Chicago, the hub of the national rail network, Debs leads a strike by the largest railroad union against any railroad that uses Pullman railroad cars. The Pullman factory was in Chicago. It made a popular sort of rail car that was widely used. A lot of what he saw to be unsafe, unfair conditions in the factory. The strike sort of kind of worked. A lot of unions were like, I don't think so. But Debs persuaded his union to strike, and it brought rail traffic to a stop in Chicago and thus the entire country. This is a problem. People start complaining. The Cleveland administration tells them, go sue Debs for something. So they sued Debs for something and got an order saying, stop striking. And Debs said, to hell with you, I'm going to keep right on striking. And he kept on striking. And the military got involved, posse comitatus, I'm not sure how that worked, but the Army took control of the train depots in Chicago. There was rioting all across the country. A lot of people died. It was a very, very difficult situation. Ultimately, the strike was put down. Mr. Pullman went back to making cars. The railroad started running, and Debs ended up in jail for contempt of court. Debs hired Clarence Darrow, who was kind of the David Boies of his time, and took his case to the Supreme Court saying, a train just hit me. What just happened to me? This wasn't fair. As you may have gathered from Ex Parte Young, the railroads had a lot of stroke in the late 19th century, so it didn't go well for Debs. But it is worth, I just wanted to show my postman poster. But the point, here's what the U.S.'s argument was in this case. They said the Article 1 of the Constitution gives the national legislature the express power to regulate interstate commerce and to deliver the mail. And we have all these trains that is how we do interstate commerce in this country, and it's how we deliver the mail. And a strike that shuts down the trains prevents us from regulating interstate commerce, and the mail can't be delivered. And so when we have a national express command from the Constitution that there should be commerce and there should be mail, and you are stopping that, we have an ability to go as a sovereign. We, by the people, deliver the mail. And we can't deliver the mail, we have the right to and get appropriate relief to get rid of that obstruction. And this is the part where it gets interesting for the purposes of the present discussion about the abortion statute. There's a big lead up in the opinion that talks about the mail, which is so quaint, by the way. Mail, letters, stamps. That was a big deal then. Stamps. Have you seen a stamp lately? I haven't seen. So the mail, it's so old school. But they say okay, mail is great, but we're not really just about mail here. And then they get all high horse, and they say any the parent stuff earlier. This is the closest the U.S. Supreme Court's ever gotten to this. Any sovereign, any government has the duty to discharge for the general welfare. We talked about the general welfare for a while, and you can do whatever you need to do to put Eugene Debs in jail and do things for the general welfare. And that is sufficient by itself to give the United States standing in court. To be quaint, they call it a standing in court. That's broad stuff. But the Supreme Court went way out of its way to say this. They could have stopped with the mail, and they could have stopped with interstate commerce. As we all know, the commerce power is vastly broad. But they didn't stop there. And they went further and said, if you're a sovereign, you have to have some ability to do things to make the welfare of the people. And the argument was made that Debs said, well, if I'm violating laws about the mail, prosecute me for that. Sue me. Prosecute me for violating the mail thing. Get a bunch of good Chicago rail workers on that jury. We'll all be acquitted. And we can argue about the constitutional stuff all day long in my criminal case. The court in Debs, like it did in Ex Parte Young, says you shouldn't have to wait. The problem was not whether Debs was interfering with the mail, it was that there was no mail. The trains had shut down, and waiting to develop some case against him and prosecute him at a later date wasn't going to solve that problem. It may be that Mr. Debs ends up in jail. That was his campaign button for one of his many presidential campaigns. That's a catchy slogan, isn't it? Vote for me, I'm a good convict. Whatever works. That's that was the court rejected that argument. Now, some of that is driven by the fact that railroads had a lot of stroke. But the United States has made a big deal out of this case in its briefing in front of the Supreme Court and said, and the points made by the court here are the subject of a lot of discussion in the oral argument. The question of express rights, express powers of government is central to this. Even though the Supreme Court said we're really waxing poetic about the general powers of government, no one really wants to go there. And in fact, cases that have cited Debs, there haven't been a lot. There aren't a lot of riots shutting down the rail system, mercifully, in this country. But they have been careful to tie it to something in Article 1, Section 8 that's an express delegation of power. People are very uncomfortable with this. And the state of Texas has noticed that and said, we look at Article 1, Section 8, and it doesn't say anything about medicine, and it sure doesn't say anything about abortion. Roe it comes from a different place. We're not suggesting that it's not legitimate law. We will in 2 weeks. But for today, we're not arguing about that. But it's just different. That's something else other than something that the Constitution expressly tells the United States government to go address. That's all pretty wispy stuff. There's not cases that guide you on any of that. It's basically people pointing at the Constitution and saying, I like that part. But that's what we've got on this situation. And so the threshold question is, are the rights guaranteed by Roe and Casey something similar to what was under discussion in Debs, or are they not? This part of it is very interesting, because that's the second time that the Supreme Court in a high-profile case said you shouldn't have to wait. A current situation that's a big mess is something that courts are able to resolve. And yeah, there may be criminal consequences. Yeah, there could be civil suits and damages someday. But in Ex Parte Young, they came up with the idea of suing Mr. Young. Here, they came up with an injunction against Debs shutting down the rail system. You don't have to wait if there's a crisis. And that observation is a central part of the United States position in its case, which is there's a problem here. There's this, that abortions are not being performed. The courts aren't able to act otherwise. You have that kind of power. And yeah, we don't have a case that says that, but you sort of just have to have it. It's by the nature of sovereignty, by the nature of being a court. And they cite this general language in Debs. That's the second question. is the later possibility of judicial review sufficient in this setting, or is the current situation analogous to the kind of crisis that we faced in Debs? Debs is not going to control this because it's on point, and the Supreme Court comes out with a case that says, we were just reading the holding in Debs, and I'll be darned, it's on point. No. But they can say, if they were inclined to go with the United States side of it, here's a case that's 100 and something years old and is different, but the logic of it we like, and we're going to follow it and adapt it to this particular situation. So that's the question is, that's powerful stuff, right? Saying that a federal court can just go and enjoin people for the public good. What? And Texas makes a big deal out of that in their briefing, which is, what? What does that mean? But the answer is, this kind of case comes along once a century, and yeah, you have to tie it to something. We have. There's a specific, in that case, it was a specific government power. Here, it's this wacky statute that's managed to get around all traditional concepts of judicial review, and there's an immediate problem. It's not the national economy, but it's a model for avoiding judicial review that has a real effect in Texas. And of course, if you heard the question between Justice Kavanaugh and the Solicitor General of Texas, what happens when you turn this to gun control? No really good answer to that. You can use anything. So that's the balance that we face in trying to apply Debs. So those are the 4.5 doctrines that Professor Moriarty has put into effect. Extraordinary draftsmanship. One sentence in this law, you've seen it a couple of times now, implicates all of these different doctrines. That's clever work. And whether or not you agree with it, whether or not you agree with the applications of these doctrines or by names of them, you got it. That's some clever drafting. And it's forced the highest levels of the U.S. government to sort of confront what is it that courts do in this society? What are the limits of federal courts compared to legislatures? And there are all these rules we developed that just aren't functioning here. One side of the question says. The other says, well, looks just fine to us. So how we resolve all of that has even if the court doesn't address all these doctrines and their opinions on this issue, where it goes with this obviously has consequences for these doctrines because it's indirectly saying things about them, kind of like cases like Debs and Ex Parte Young did. I think we may be out of time. All right.
Thank you very much. If there are other questions, we can still
ask. All right. No, thank you very much. Thank you.